CIV3701, Stage 2, Part 2B, Pre-Trial Procedures. Number 1. Introduction. Once pleadings close, the issues in dispute between the parties are clear. The matter is not, however, ready for trial. There is usually a long wait which must last several months before the trial takes place. Having regard to what has been admitted and what has been placed in issue, the attorney must now establish what evidence is required to prove the allegations made in the pleadings in order to support the cause of action or defense, as the case may be. Having decided what evidence is required, the next step is to obtain it. It is also necessary to subpoena witnesses to ensure their attendance at trial, collect all the documents that will be needed in evidence, as well as any exhibits, plans, photographs, and the like. Note that there are few secrets in a civil trial. The procedures are all aimed at allowing the trial to run smoothly, avoiding adjournments and delays, and encouraging settlement by allowing both sides to have insight into the case which is being prepared by their opponent. The preparations for trial include the following procedures. Step 1. Setting down the matter for trial. Step 2. The discovery process, that is, the process of revealing documents and other recorded evidence for inspection by the other side, so that neither is taken by surprise at the trial, as well as ancillary procedures such as asking the other side to specify precisely which documents and other recorded evidence they intend to use at the trial. Step number 3. Technical and medical examinations. In some matters, it may be necessary to determine the state of an object, which is crucial to the outcome of a trial, by means of a technical inspection, or to have a party claiming damages for bodily injuries medically examined to determine the nature and extent of his injuries. Step number 4. Obtaining further particulars for trial. Step number 5. Having the necessary subpoenas issued for the witnesses who are to give evidence at the trial or who are to bring documents in their possession to the trial. And step number 6. Arranging for special evidence, such as evidence by expert witnesses. The other side must be given advance warning so that they may consult their own experts. Evidence contained in the form of photographs, plans, diagrams, or models. The other side may be prepared to admit that they are accurate, which will save time at the trial. Evidence on commission. In rare cases, it may be possible to obtain evidence from a person who cannot or will not come to court to testify in person. Evidence by interrogatories, that is the same as evidence on commission, except that a predetermined list of questions is put to the witness. Evidence on affidavit, this is only allowed in rare cases, usually if the evidence is purely formal and will not be contested. Step number 7. Arranging and attending a pre-trial conference, at which a final attempt is made to settle the matter, and final arrangements for the trial are discussed by the parties. Furthermore, depending on the practice in your division and the nature and complexity of the matter, attending judicial case flow management meetings. Number 8. A final preparation for trial, that is, advice on evidence. Okay, and number 2. Step number 1. Set down. Close of pleadings is provided for in terms of Rule 29 of the High Court Rules and the identically worded Rule 21A of the Magistrates Courts Rules. These rules are self-explanatory and read as follows. Pleadings shall be considered closed A. If either party has joined issue without alleging any new matter and without adding any further pleading. B. If the last day allowed for filing a replication or subsequent pleading has elapsed and it has not been filed. C. If the parties agree in writing that the pleadings are closed and such agreement is filed with the registrar. Or D. If the parties are unable to agree as to the close of pleadings and the court upon the application of a party declares them closed. Number 2.1. Set down in the High Court. As soon as the pleadings are closed, the matter must be set down for trial. In other words, a trial date must be obtained from the court and the opposing party informed. The plaintiff, as dominus litis, has the right to apply for set down in the first instance. If he fails to do so, then any party may place the case on the roll for hearing. There are no provisions dealing expressly with set down. Each division of the High Court has its own rules for setting down a matter. We shall examine the practice followed in the division of the High Court situated in KwaZulu-Natal as an example. Once the pleadings close, the plaintiff usually drafts a notice addressed to the registrar requesting him to place the matter on the awaiting trial roll, that is, the long list of cases waiting to be allocated a trial date. This notice includes details of the case number and the parties to the action, the names of the advocates and the firms of attorneys representing the parties, and the number of days which the plaintiff estimates that the trial of the action will last. The average number of days requested in the High Court tends to be 3 days. This notice is filed with the registrar and served on the opposing side. In the Durban seat of the KwaZulu-Natal division, the practice is for the person delivering the notice to enter the information in a book at the general office. If this is not done, the notice merely languishes on the court file. It is advisable, therefore, to send a responsible person to court with the notice. Once the registrar has placed the matter on the awaiting trial roll, the parties must await for a trial date to be allocated. Depending on how many days have been requested, a delay of anything between 6 months and 2 years may be expected before a date is allocated for the trial of a matter, although the trial backlog has abated somewhat in certain divisions since the introduction of the judicial case flow management. If the registrar is asked to set aside 2 days for the trial of a particular matter, a trial date will be allocated sooner than if 5 days are requested for the trial. However, an attorney may not jump the queue by asking the registrar to allocate 2 days for the trial of a matter when he knows that the particular matter will take 5 days to complete. In such a case, the matter will become part heard and the attorney will probably have to wait longer to have the matter finalized than if he had set the matter down for 5 days in the first place. The court may also decide to penalize him with an adverse award of costs if it is clear that the matter ought to have been set down for a longer period. Also, if it is clear that the requested time is insufficient at the outset, the court may refuse to hear the matter and require that it be set down again. The next thing that will happen is the registrar will send the so-called weekly list to the firm of attorneys who set the matter down. The weekly list is simply a list of all the matters that are to be trialed in that particular division during a particular period. The list is sent to all the attorneys involved in the matters listed and to the parties themselves if they are not represented by attorneys, and will arrive by registered post at each firm at least 6 weeks before the date on which the matter is to be tried. It is good practice to serve a notice of set down on the other side immediately, which will indicate the dates which have been allocated for the trial, so that there can be no question that they are aware of the dates on which the trial will be held. Number 2.2. Set down in the Magistrates Courts. In the Magistrates Courts, the procedure is slightly different in that only one notice of set down is delivered, both requesting a trial date and informing the defendant that the matter has been set down for trial on a particular date. The plaintiff must deliver this notice of set down to the defendant within 15 court days after pleadings have closed. Unlike the list system employed by the registrar in the High Court, the clerk of the civil section in a magistrate's court assigns a court day on receipt of the notice and immediately endorses the notice with the trial date, before returning the notice to the plaintiff for service on the defendant. At least 20 court days must elapse from the date on which the notice of set down is delivered to the date on which the trial begins. There is usually no danger of short service as the courts appear to be congested and attorneys report delays of between 6 months and a year in some of the larger magistrates' courts. This will vary considerably, however, depending on both the size of the courts and the efficiency of the staff at each court. The notice of set down operates to set down simultaneously for trial any counterclaim brought by the defendant. If the plaintiff does not deliver the notice of set down within the required 15-day period, the defendant may set the matter down for trial by delivering the required notice. The defendant will do this if he has brought a substantial counterclaim against the plaintiff and wishes to proceed to trial. The 2010 amendments to the Magistrates Courts rules have made provision for magistrates to take the initiative with regard to holding a Section 54 conference. This sub-rule 4 provides that on receipt of application for a trial date, the registrar or clerk must draw the court file and take it to the magistrate in order for the magistrate to determine whether a pre-trial conference in terms of Section 54 is necessary. Sub-Rule 5 provides special provision for the set down of divorce hearings in the regional magistrates' courts. Promoted by the written request of the plaintiff, the registrar sets the matter down for hearing at the time, place, and date fixed by the registrar, provided the defendant has, number 1, failed to deliver notice of intention to defend, or, number 2, failed to deliver a plea after receiving a notice in terms of Rule 21b, Subsection 2. Or, lastly, number 3, given written notice on the plaintiff, to the plaintiff and the registrar or clerk of the court that he or she does not intend defending the action. However, no notice of such request or set down need be served on the defendant. Sub-Rule 6 provides that when an undefended divorce action is postponed, the action may be continued before another court, notwithstanding that evidence has been given. Number 3. Step 2. Discovery and related procedures. 3.1. What is discovery? Usually, a portion of the evidence in legal cases consists of information recorded in documents, on computer disks, or in other ways. The purpose of discovery, as the name indicates, is to allow each party knowledge of and eventual access to documents in the possession of the opposing party that might be relevant to the trial. Each party then knows which documents are in existence that may assist his case or his opponents. This prevents the parties from being taken by surprise, eliminates disputes about issues where the evidence is incontrovertible, and secures the fair trial of the action in accordance with the due process of the court. In other words, the litigation process is meant to be a transparent one, unlike the popular perception created in films where lawyers are forever springing unpleasant surprises on their hapless opponents. The request for such information and the manner in which such information is to be furnished is governed by Rule 35 in the High Court and Rule 23 in the Magistrates Courts rule. Rule 23 was amended in 2010 so as to replicate Rule 35 in its entirety, with minor differences in wording and sub-rule numbering. Note that pre-action discovery in terms of Section 50 of the Promotion of Access to Information Act No. 2 of 2000 PR is not available to litigants as part of the discovery process in civil cases. It is only available where the requester has shown the element of need or substantial advantage of access to the requested information at the pre-action stage. Furthermore, due to an exclusion contained in Section 7 of PR, requests for access to records may be made for the purpose of litigation after litigation has commenced are regulated by rules of court, that is, Rule 38 and not PR. Number 3.2. Discovery procedures. Number 3.2.1. Notice to discover. Number 3.2.1a. When must discovery take place? Discovery is usually prompted by a notice to discover served on a party by the opposing party. The rules require that discovery should occur on oath, and so the lists or schedules of the documents a party discovers are annexed to a discovery affidavit. A party's discovery affidavit must be delivered within 20 court days of the receipt of a notice to discover from the opposing party. Unless the leave of a judge or magistrate is first obtained, discovery may not be requested before the close of pleadings. It is not only in response to a notice to discover, however, that a party is obliged to deliver a discovery affidavit to the opposing party. If a party fails to call for discovery by serving a notice to discover, the action will reach a point at which the opposing party will be obliged to deliver a discovery affidavit to the other party without the prompting of a notice. In terms of Rule 37, Subsection 1, if a party has not yet discovered by the time he receives the notice of the trial date, in other words, the weekly list of cases for trial sent out by the registrar, then he must deliver his discovery affidavit to the other side within 15 court days. The implication of Rule 37, Subsection 1 is that each of the parties must discover, even if they have not specifically been requested to do so by the opposing party. In other words, Rule 37, Subsection 1 provides for automatic discovery. There is no corresponding Magistrates Courts provision, however, which means that although a party may discover voluntarily, discovery in the Magistrates Courts is only mandatory on the receipt of notice to discover from the opposing side. The parties may be penalized by way of a costs order, however, if they fail to call for and to make discovery. Number 3.2.1b. What must be discovered? A notice to discover contains a request for the opposing party to discover on oath, first, all documents and tape recordings which relate to any matter in question in the action, or secondly, which the other side have in their possession or control when the notice is delivered, or which they have at any time in the past had in their control or possession. The term tape recording includes a soundtrack, film, magnetic tape, record, or any other material on which visual images, sound, or other information can be recorded. In other words, compact discs, computer hard drives, videotapes, and photographs would all fall within the meaning of a tape recording, as used in High Court Rule 35 and Rule 23 of the Magistrates Courts rules. These rules therefore give the expression tape recording an extended meaning. Note that it is not only the documents and tape recordings currently in a party's possession or control that must be discovered, but also those which have been under the party's control at any time in the past. Documents and tape recordings in a party's possession or control include those that are in the possession of a party's attorney. They do not include documents that are in the possession or control of one of the witnesses, however, unless they are at one time under the control of the party. A witness who is not a party to the proceedings may not be compelled to discover, but only to bring the documents to court under a subpoena ducis tecum. Further, a party may not limit his discovery to the documents and tape recordings he intends to use in support of his case at trial, or merely those favorable to his case. All documents which relate to any matter in question in the action must be discovered, whether they help or hinder a party's case. The purpose of this is to establish complete transparency and thereby avoid the litigation dragging on for no good reason. Whether or not a document is relevant is determined with reference to the issues in dispute as they are disclosed in the pleadings. A document will be relevant if it contains information that might directly or indirectly advance a party's case or damage that of his opponent. It will be indirectly relevant if the information may fairly lead to a train of inquiry that may advance his case or damage that of his opponent. The test for relevance is accordingly generous. There is a small category of mostly privileged documents, however, which the opposing party is not entitled to inspect. These documents do not form part of the discovery affidavit and are omitted from the schedule. Number 3.2.1 C. The discovery affidavit. High Court Form 11 and Magistrates Courts Form 13 prescribe what the discovery affidavit referred to in Rule 35, Subsection 2 and Rule 23, Subsection 2, respectively, must look like. According to Forms 11 and 13, these are two schedules to a discovery affidavit. The first schedule lists those documents and tape recordings in the extended meaning, which are in the possession of the deposing party at the time the discovery affidavit is deposed to. The first schedule is divided into two parts. The first part of the first schedule contains those documents and tape recordings that the deposing party has no objection to being inspected by the opposing party. Each document listed in the schedule should be identified by a description which will usually include its date. It is also customary to number each document and indicate whether or not the document is an original or a copy. It appears that it is obligatory to list documents in chronological order, which prevents an attorney from burying a document. It is certainly not sufficient for a party in custody of a large volume of documentation to point to a storeroom and give access thereto his adversary with an injunction to inspect and copy to his heart's content. Where there is a large number of documents of the same type, such as invoices, it would be pointless and time-consuming to itemize. They are deemed to be sufficiently identified if described as being one of a bundle of documents of a specified nature which have been initialed and consecutively numbered by the deponent. In this case, the bundle rather than the individual document that constituted would be described. For example, a bundle of plaintiff's current bank account statements from so and so date, the originals. Documents must therefore either be described individually, initialed and consecutively numbered, or labeled as a bundle of documents of a special nature. In some jurisdictions, the bundles must be initialed and consecutively numbered by the deponent. The second part of the first schedule contains those documents and tape recordings which the deposing party objects to being inspected by the opposing party. There may, in theory, be other valid grounds for objection, but in practice, the reason will almost certainly be that the documents are privileged on the basis of the rules of evidence. The following list is not exhaustive, but includes examples of documents that are privileged. Number 1. A document implicating a party in a criminal offense, which is protected by the privilege against self-incrimination. Number 2, a document written by one spouse to another spouse, which is protected by marital privilege. Number 3, a written offer made without prejudice with the intention of settling a matter. And lastly, a document written by an attorney or advocate to his client, or vice versa, which is protected by legal professional privilege. In theory, documents for which privilege is claimed must be separately listed and identified in the schedule, and the grounds for each particular privilege specified. This is not the case with the privileged documents specifically referred to in Rule 35, Subsection 2, or Rule 23, Subsection 2 of the High Court and Magistrates Courts, respectively, namely, statements taken from a witness for the purposes of the proceedings, and communications between attorney and client and attorney and advocate, which, as indicated below, must be excluded from the schedules altogether. It must be said, however, that in practice this rule is observed in the breach, and it is extremely rare in both the High Court and Magistrates Courts to see any privileged documents of whatever nature actually listed and itemized. The second part tends instead to consist of a standard generic list of the general types of documents which are privileged, without specifically referring to or identifying any document in particular. Although this practice contravenes the rules, it is rarely challenged, either because of habit on the part of practitioners or by implicit gentleman's agreement not to have to identify privileged documents. The fear here would be that the opposing side might gain a tactical advantage from merely knowing of the existence of privileged communications at some point, even if they do not have access to the actual contents. The second schedule lists those documents and tape recordings by the extended meaning which were in the possession of the deposing party at one time but are no longer in the possession of that party. Second scheduled documents will, in theory, include the original copies of all letters dispatched by the deposing party. In practice, correspondence tends not to be separated in this manner, but is entered in the first schedule and is merely listed as a copy if the letter has been dispatched to someone else, unless no copy exists. Less commonplace documents that are no longer in the deposing party's possession, such as agreements, are the type of documents that tend to be listed in the second schedule. In terms of Rule 35, Subsection 2 of the High Court's rules, or Rule 23, Subsection 2c of the Magistrates Courts rules, the only documents and tape recordings which need not and indeed must not be listed in the schedules attached to a discovery affidavit are the following. First, statements of witnesses taken for the purposes of the proceedings. Secondly, communications between attorney and client and between attorney and advocate. And lastly, pleadings, affidavits, and notice in the action. Number 3.2.1d. Remedies for failure to discover. Number 3.2.1d1. Notice to inspect undisclosed documents. Rule 35, Subsection 3 in the High Court and Rule 23, Subsection 2 in the Magistrates Courts. Rule 35, Subsection 3 of the High Court rules and Rule 23, Subsection 3 of the Magistrates Courts rules set out the procedural steps that may be taken if the opposing party has not discovered certain documents or tape recordings that are relevant to the case. In terms of this rule, a written notice must be delivered to the opposing party in which that party is required either, number 1, to make the undiscovered documents or tape recordings or copies of them available for inspection, or number 2, to state on oath within 10 days that such documents are not in his possession, in which event he shall state their whereabouts if known to him. The notice may relate to a particular document that the party giving notice knows to exist, or to a category of documents such as the bank statements of a business, which reasonably may be presumed to exist, but of which the party giving notice has no actual knowledge. It goes without saying that it is unethical, unlawful, and a breach of an attorney's duty as an officer of the court knowingly to assist a client to lie under oath. In other words, if you know that your client has a document in his possession, you would be very foolish indeed to assist him in making a statement under oath that such document is not in his possession. Number 3.2.1d2. Documents or tape recordings may not be used. Rule 35, Subsection 4 of the High Court and Rule 23, Subsection 4 of the Magistrates Courts. The consequences to a party of failing to discover a document or tape recording are set out in Rule 35, Subsection 4 of the High Court rules and Rule 23, Subsection 4 of the Magistrates Courts rules. That party may not, save with the leave of the court, use the undiscovered document or tape recording for any purpose at the trial. The opposing party, however, is entitled to use that document or tape recording at the trial. Number 3.2.1d3. Application to compel discovery. Rule 35, Subsection 7 of the High Court and Rule 23, Subsection 8 of the Magistrates Courts. Should a party fail to discover, his opponent may make an application to court under Rule 35, Subsection 7 of the High Court rules and Rule 23, Subsection 8 of the Magistrates Courts rules to compel discovery. At the hearing of the application to compel discovery, the court will order the recalcitrant uncooperative party to deliver a discovery affidavit before a certain date. If the discovery affidavit is not delivered by that date, a further application may be made to court to dismiss the claim or strike out the defense of the recalcitrant party. Note that the dissatisfied party need not send a notice in terms of Rule 35, Subsection 3 of the High Court's rules and Rule 23, Subsection 3 of the Magistrates Courts rules before making an application to compel discovery. Number 3.2.2. Notice to inspect. Having received the opposing party's discovery affidavit, a party will in all likelihood wish to inspect some of the documents which are described in it. In terms of Rule 35, Subsection 6 of the High Court's Rules and Rule 23, Subsection 6 of the Magistrates Courts Rules, one party may deliver a notice to another party, requiring that party to produce for inspection any of the documents or tape recordings which that party has discovered in his discovery affidavit. The notice must be in accordance with Form 13 and Form 15 of the High Court and Magistrates Courts Rules respectively. Rule 35, Subsection 6 of the High Court and Rule 23, Subsection 6b of the Magistrates Courts provide that the party upon whom the notice to produce for inspection is served has 5 court days within which to deliver a notice to inspect documents, which is essentially a reply to the notice to produce for inspection. The notice to inspect documents must be in accordance with Form 14 of the High Court and Form 15a of the Magistrates Courts, and must state a time which is within 5 court days after the delivery of the notice when the documents or tape recordings listed in the notice to produce for inspection may be inspected. The inspection must take place at the office of the attorney representing the party sending the notice to inspect documents, or if that party is not represented by an attorney, at a convenient place set out in the notice. Where the documents to be inspected are bankers' books or other books of account or books in constant use for the purpose of any trade, business, or undertaking, they will normally be expected at the place at which they are usually kept. The party receiving the notice to inspect documents will be entitled to inspect the documents and tape recordings for a period of 5 court days from the time stipulated in the notice to inspect documents. He may inspect the documents on any one or more of such days during normal business hours and may make copies or transcriptions of them. In terms of Rule 35, Subsection 6 of the High Court and Rule 23, Subsection 7b of the Magistrates Courts Rules, if a party fails to produce a particular document or tape recording for inspection, then that party will not be permitted to use that document or tape recording at the trial unless he convinces the court that there was good cause why the document or tape recording was not produced. The procedure provided in Rule 35, Subsection 7 of the High Court's Rules and Rule 23, Subsection 8 of the Magistrates Courts Rules may be used to compel the other party to produce a document or tape recording referred to in the discovery affidavit for inspection. The aggrieved party may apply to court which may order compliance by the other party. Failing such compliance, the court may dismiss that party's claim or strike out that party's defense. In practice, when there are not many documents listed in a discovery affidavit that a party wishes to see, that party's attorney may telephone or write a letter to the opposing party's attorney requesting him to dispatch photocopies of the documents. The requesting attorney will tender the reasonable cost of the copies. Number 3.2.3. Notice to specify. The rules also provide a means for ascertaining exactly which documents or tape recordings the opposing party intends to use at the trial. In terms of Rule 35, Subsection 8 of the High Court Rules and Rule 23, Subsection 9 of the Magistrates Courts Rules, any party to an action may, after the close of pleadings, give notice to any other party to specify in writing particulars of dates and parties of or to any document or tape recording intended to be used at the trial of the action on behalf of the party to whom notice is given. The party receiving the notice to specify must, not less than 15 court days before the trial, deliver a notice to the party who sent the notice to specify, in which he, firstly, specifies the date of and parties to and the general nature of any documents or tape recordings which are in his possession and which he intends to use at the trial of the matter, and secondly, specifies any particulars whereby those documents or tape recordings which are not in his possession and which he intends to use at the trial of the matter may be identified, as well as the name and address of the person in whose possession such documents and tape recordings are. The notice to discover that is Rule 35, Subsection 2, results in the delivery of the discovery affidavit, which contains a comprehensive list of all the documents which the opposing party has or has had in his possession. To narrow the focus on the most important documents required for trial, the notice to specify is used, as per Rule 35, Subsection 8. The response to the notice to specify will reveal the chain of documents and tape recordings upon which the opposing party's case is based, allowing the requesting party to prepare an adequate response. A point which is often missed by practitioners is that this rule requires discovery beyond that which is contained in the discovery affidavit of the party receiving a notice to specify. A Rule 35, Subsection 8 in the High Court or Rule 23, Subsection 9 in the Magistrates Courts notice is not only requires information about documents that are currently in the possession of the opposing party or those which were in his possession in the past, it also requires information about documents that have never been in the opposing party's possession. These would include documents which are in the possession of third parties but which the opposing party wishes to make use of at the trial by means, for instance, of a subpoena ducis decem. Also, in terms of this sub-rule, the party receiving the notice to specify should disclose in his reply any documents of the opposing party that he wishes to use at the trial. The party to whom notice has been given is not obliged, however, to inform the opposing party of privileged documents which he might use to attack the evidence of witnesses that the opposing party has called. A further point is that this notice may be delivered at a time after close of pleadings and is not contingent, that is, dependent on the discovery affidavit. In practice, this notice is often delivered together with all the other discovery notices and then completely ignored by both parties. Occasionally, a response to the effect that the opposing party intends to use all the documents disclosed in his discovery affidavit is received. This would be adequate if indeed it were the case, but objection should be raised if the opposing party attempts thereafter to lead evidence of documents in the possession of third parties, or if the party giving notice to specify at the trial. There is no specific sanction for the non-observance of this sub-rule, but the court may make an order to prevent any party being prejudiced thereby. The prejudice submitted would include both the loss of the tactical advantage provided by the sub-rule and the possibility of being taken by surprise. Enforcing the rule by way of Rule 30A in a High Court matter or Rule 60, Subsection 2 in the Magistrates Courts is another possibility. Number 3.2.4. Notice to produce. Rule 35, Subsection 10 of the High Court Rules and Rule 23, Subsection 11 of the Magistrates Courts Rules set out the procedure whereby a party may oblige another party to produce the original of a discovered document at the hearing of the matter. In other words, a party will use this procedure if he wants the opposing party to bring one of that party's documents or tape recordings to the trial. The reason a party would want the opposing party to do this is because he wishes to use that document or tape recording in support of his own case. By following this procedure, a party is entitled at the trial to hand in the document or tape recording concerned, without calling any witnesses. The document or tape recording will be received into evidence as if it had been produced in evidence by the person to whom the Rule 35, Subsection 10 or 23, Section 11 notice was given. A notice to produce may not be used to obtain documents currently in the possession of third parties that have been discovered for the reason that they were once in the possession of the party making discovery. The approach often used in practice of sending all the discovery notices together, including the notice to produce, at the start of the discovery process preceding the opposing party's discovery affidavit as it does, usually requires the opposing party to produce all the originals of all the documents discovered. This mechanical approach is hardly what the rule envisages. Neither do the party who use this approach employ the sub-rule in a useful fashion. There is no need to use a blanket approach in order to avoid missing a document, since although the notice should normally be delivered at least 5 days before the trial, there is provision in the sub-rule for the court to allow notice to be given at the trial itself. Number 3.2.5. Notice to admit. For a document to form part of the evidence at trial, a witness who has knowledge of the document and who is able to identify it for the court must introduce the document. Rule 35, subsection 9 of the High Court Rules and Rule 23, subsection 10 of the Magistrates Courts Rules provide a method of avoiding this in certain circumstances. They provide a procedure whereby one party may call upon the other party to admit that certain documents or tape recordings were properly executed and are what they purport to be. A notice to admit is served on the opposing party, who then has 10 court days to make up his mind, unless the party to whom the notice was sent specifically states that the documents or tape recordings are not admitted. The party who sent the notice is entitled to produce the documents or tape recordings specified in the notice at the trial without having to prove them. For example, if one of the documents concerned is a contract between two extraneous parties, it may be submitted in evidence without having to call the parties who entered into the contract to attest to the fact that this was the contract entered into by them. It will be assumed, in other words, that the contract is what it purports to be. This rule is especially useful when the documents are in the hands of third parties, such as municipalities, where thousands of official documents are kept on file. It saves the filing clerk, who has the document in his possession and is able to identify it but has no direct knowledge of its contents, from making a pointless and expensive trip to court under a subpoena ducis tesum, merely to confirm that the document in question comes from his files. Should a party unreasonably refuse to admit a document, the court may order that party to pay the costs of its proof. Note that a party who admits a document under this sub-rule is not precluded or prevented from challenging the veracity, the truth, or accuracy of the document, as it is the identity of the document, not its contents, which is admitted. Number 4. Step 3. Medical examinations and technical inspections. Preparation for trial also involves the examination of evidence other than documents or recordings. This evidence will vary considerably from plans, diagrams, and photographs to other physical pieces of evidence of whatever kind. Examples could include anything from a damaged motor vehicle to defectively manufactured concrete blocks. Examining evidence of injuries is also necessary in respect of personal injury claims, such as those arising out of motor vehicle collisions. The rules of court provide pre-trial procedures for examining evidence of this nature that resides in the hands of the opposing party. The relevant rules applicable in the High Court and Magistrates Courts, respectively, are Rule 36 in the High Court's Rules and Rule 24 of the Magistrates Courts Rules. These two rules are virtually identical in all but minor detail, with the numbering of the sub-rules closely, if not exactly, corresponding in each case. The comments in relation to these rules set out below apply equally to the practice in both courts, but to avoid confusion, we shall concentrate on the High Court Rule 36, noting any differences that exist in respect of Rule 24 of the Magistrates Courts Rules as they arise. Number 4.1. Medical examinations. Claim for bodily injuries. Rule 36 of the High Court Rules and Rule 24 of the Magistrates Courts Rules provide identical procedures for use by a defendant who is being sued for damages for personal injuries suffered by the plaintiff. The two sets of rules are almost identical on this issue, and only the High Court Rule will be referred to at this juncture, so as to avoid overburdening the text. The procedure involves the examination of the plaintiff by a suitable medical practitioner. The purpose of the procedure is to enable the defendant to ascertain the extent and severity of the plaintiff's injuries, mainly for the purpose of assessing whether or not the quantum value of the plaintiff's claim is reasonable. In certain circumstances, it may be possible to deduce the manner in which the injury occurred from the nature of the injuries. Number 4.1.1 Arranging the examination. In terms of Rule 36, Subsection 1 of the High Court rules, any party to proceedings in which damages or compensation in respect of alleged bodily injury is claimed has the right to require any party claiming such damage or compensation whose state of health is relevant to the determination of such damage or compensation to submit to a medical examination. Rule 36, Subsection 5a also provides for a party claiming damages as the result of the death of another person to undergo a medical examination where his own medical condition is relevant to determining the damages. The damages in a loss of support claim such as this are determined by an actuarial assessment based on the ability to work and the life expectancy of the claimant, hence the need for an examination. The procedure for the examination is set out in Rule 36, Subsection 2, which reads inter alia as follows. Any party requiring another party to submit to such examination shall deliver a notice specifying the nature of the examination required, the person or persons by whom, the place where and the date being not less than 15 days from the date of such notice, and time when it is desired that such examinations shall take place, and requiring such other party to submit himself for examination then and there. Such notice shall state that such other party may have his own medical advisor present at such examination, and shall be accompanied by a remittance in respect of the reasonable expense to be incurred by such other party in attending such examination. The expense envisaged by the rule is based on the scale of witness fees in a civil suit and includes transport costs and loss of income. The rule makes provision for special transport costs in the case of someone who is unable to move unassisted, including the use of a motor vehicle and a person in attendance. The loss of income is restricted to an amount of 75 Rand a day. The expenses involved in holding the examination become costs in the cause, unless the court directs otherwise. Although Rule 36, Subsection 2 is silent on the question, it seems that the legal advisor of the person being examined is also entitled to be present at the examination. The rule does not indicate at which stage of proceedings a notice under Rule 36, Subsection 1 should be delivered, but the usual time is after close of pleadings in preparation for trial. However, a defendant wishing to assess the quantum of a plaintiff's claim in order to make a prompt settlement offer may well wish to have the plaintiff's injuries assessed as early as the time he receives the summons. In certain cases, a second medical examination may be necessary, which is provided for by Rule 36, Subsection 5. Number 4.1.2. Objecting to the examination. The party who is being requested to submit to the examination may, within 5 court days of the receiving notice of the proposed examination, object to the examination on the following grounds set out in Rule 36, Subsection 3. Number 1. The nature of the proposed examination. Number 2. The person or persons by whom the examination is to be conducted. Number 3. The place, date, or time of the examination. In this case, he must suggest an alternative date, time, or place. And number 4. The amount of the expenses tendered to him. In this case, he must give full details as to why he should be entitled to an increased amount. Should the party fail to object within the 5-day period, he is deemed to have agreed to the examination on the terms set out in the notice. Where objection is made and the party who has delivered the notice demanding the examination regards the objection as unfounded, he may, on notice, make application to a judge to determine the conditions upon which the examination, if any, is to be conducted. Number 4.1.3 Reports on the examination. In terms of Rule 36, Subsection 8a, the party calling for the examination must ensure that a full written report is compiled by the person who carries out the examination. The report must detail the results of the examination as well as the opinions formed by the person who conducted the examination. A full copy of the report must be made available to any party to the matter who requests it. Number 4.1.4 Other medical reports, records, x-rays, etc. In terms of Rule 36, Subsection 4, a party to proceedings in which damages or compensation in respect of an alleged bodily injury is claimed may require the party who is claiming the damages to make available any medical reports, hospital records, x-rays, or similar documentary information, which is relevant to the assessment of such damages. The party claiming the damages may also be requested to provide copies of the said documents. The request is made by way of a notice in writing, and the documents must be delivered within 10 days of service in terms of the High Court rule, and within 15 days in terms of the corresponding Rule 24, Subsection 4 of the Magistrates Courts rule. Number 4.2 Technical inspection. Claim relating to object. Rule 36, Subsection 6 deals with the inspection or examination of any object, the state or condition of which is relevant to the action. This includes both movable and immovable property, and may include anything from a motor vehicle involved in a traffic collision to an apartment in a block of flats, which is the subject of a building dispute. The rule has even been used for objects such as tape recordings that are usually thought to form the subject of discovery under Rule 35. The rule also provides for the examination of a fair sample where the case concerns a large quantity of objects from the same kind, and it is inconvenient to examine each and every individual item, for example, a defective batch of bricks. Examination under this rule may only be required of a party that has the object in his possession or under his control, and not if the object is under the control of a third party. Number 4.2.1 Arranging the inspection. The party requiring inspection must give written notice to the party in possession of the object, requiring him to make it available for inspection within a period or for a period of 10 days from the date of receipt of the notice. This may happen at any time during the course of proceedings and not only in preparation for trial. In terms of the corresponding Rule 24, Subsection 6 of the Magistrates Courts rules, however, the notice may not be given later than 15 days before the hearing. During the examination, the object remains in the possession and under the control of the party to whom the notice has been sent. Number 4.2.2 Objecting to the inspection. In terms of Rule 36, Subsection 7, the party who is called upon to submit the particular object for inspection or examination may ask the party requesting it to specify the nature of the inspection or examination. Rule 36, Subsection 6 refers to both inspection and examination, which clearly implies that scrutiny of the object may be more than visual, and may include testing, experimentation, or dismantling. If the inspection or examination will affect the object, however, causing material prejudice to the party who is being asked to submit it for inspection or examination, then that party may refuse to submit it for inspection or examination. The party possessing the object will be prejudiced if it is destroyed, damaged, or its value reduced as a result of the examination. In the event of such a dispute, either party may, on notice to the other party, refer the matter to a judge, who has a discretion to make such order as to him seems meet, and will decide whether or not the object may be inspected or examined. Number 4.2.3 Reports on the inspection. Rule 36, subsection 8 applies in the case of the inspection or examination of objects, as well as the examination of persons. As stated earlier, the person who carries on the inspection or examination is required to complete a written report, which the party who caused the inspection or examination to be made must furnish to all other parties on request. Number 4.3. Magistrates and High Courts procedures compared. Medical examinations and inspection of things in Magistrates Courts matters are dealt with by Magistrates Courts Rule 24. As noted above, Rule 24 of the Magistrates Courts Rules corresponds very closely to Rule 36 of the High Courts Rules, and the few differences that exist have been discussed in comparison with the High Court situation dealt with above. Briefly, however, number 1, Magistrates Courts Rule 24, subsections 1 to 3, 5, and 8 relate to examination of persons. Number 2, Magistrates Courts Rule 25, subsection 4 relates to medical reports, hospital records, x-rays, etc. And lastly, Magistrates Courts Rule 24, subsections 6, 7, and 8 relate to inspection and examination of objects. Number 5. Step 4. Requests for further particulars for trial. Number 5.1. What are further particulars for trial? We have noted in the section on further particulars during pleadings that a party may no longer request further particulars before replying to a particular pleading. This procedure was abolished as of the 1st of January 1988 in the High Court and the 15th of October 2010 in the Magistrates Courts. Apart from the limited exceptions explained in the section on further particulars above, further particulars are now permitted only for the purpose of preparing for trial, a procedure which is now available in both the High Court and Magistrates Courts. Now, the only further particulars that may legitimately be requested in terms of Rule 21, subsection 2 of the High Court Rules or Magistrates Courts Rule 16 are those particulars which are strictly necessary to enable the party requesting them to prepare for trial. The purposes of further particulars for trial are, first, to prevent any surprises at the trial, and secondly, to inform a party with greater precision what the opposing party is going to prove in order to enable him to prepare his case. These purposes do not include attempting to tie the other party down, thereby unfairly limiting his case. For anyone unfamiliar with litigation involving complex matters, there are at least two considerations that would seem to render the exercise of requesting further particulars at this stage in the action procedure pointless. Firstly, in terms of Rules 18, subsection 4 and Rule 6, subsection 4 of the High Courts Rules and Magistrates Courts, respectively, pleadings should already contain sufficient information to enable the opposing party to reply. This means that the facta probanda relating to the claim and defense should be known by this stage of the proceedings. Secondly, the discovery and examination procedures of High Courts Rules 35 and 36 and the corresponding Magistrates Courts Rules 23 and 24 allow the requesting party to obtain certain details about the evidence, the facta probantia, that will be presented at the trial by the other party. Further particulars for the purpose of trial, however, may be requested from sources other than pleadings and may ask limited questions about the opposing parties' sources of evidence that go beyond discovery or examination provided for in Rules 35 and 36. Although the pleadings may be a starting point for requesting further particulars for the purposes of a trial, other portions of the record, such as expert summaries and evidence from earlier hearings in the action, may also be used. With regard to the kind of information that may be elicited from the opposing side, the information furnished under this heading is a little more generous than that permitted when further particulars are requested in order to enable a party to plead. The information elicited may include evidence of a party if a party would otherwise be prejudiced in not knowing the case he had to meet. This does not mean that a party is entitled to know the precise nature of the evidence the other side is going to lead at the trial or the kind of information that might be elicited from cross-examination. He is merely entitled to such particulars as are necessary to put him in a position to prepare for trial and to prevent his being taken by surprise due to evidence against him which he could not reasonably have anticipated would be produced. In short, the request must be in respect of information, without which the party requesting would be embarrassed at trial. An example of the kind of information that may be sought by way of further particulars for the purpose of trial is information with regard to a spouse's business interests in a divorce matter. This information is not normally necessary to enable a party to plead, but may well be necessary to enable a party to direct his discovery and prepare evidence in relation to the matter of the division of a joint estate. Number 5.2. The procedure. In terms of High Court Rule 21, Subsection 2 and Magistrates Courts Rule 16, Subsection 2a, any party to an action may, after the close of pleadings and not less than 20 court days before the trial, deliver a notice requesting further particulars. In High Court matters, the request for further particulars must be signed by both an attorney and an advocate unless, of course, the party is representing himself, or the attorney is entitled to appear in the High Court. In the Magistrates Courts, only an attorney or a party who is representing himself need sign. The party who has been asked to furnish further particulars for trial must furnish them within 10 days of receiving the request, failing which the party requesting the further particulars may make an application to court to compel their delivery. In some divisions, where the order compelling the providing of further particulars is granted, it takes the form of a blanket order for compliance with the request. In other divisions, for example in KwaZulu-Natal, the court orders compliance with only the items in the request for particulars that has properly been made. If a party makes his request out of time, he may not make application to compel the opposing party to supply the further particulars requested. A party who requests further particulars which are not strictly necessary to enable the party to prepare for trial may be punished by an adverse order as to costs. Rules 21, Subsection 5 and Rule 16, Subsection 5 of the High Court and Magistrates Courts rules, respectively, clearly seek to discourage fishing expeditions. In practice, some of the information which would usually be obtained by way of a request for particulars for the purpose of trial may be sought at a Rule 37 pre-trial conference, for example when admissions are sought. Nevertheless, as this information might be used to direct discovery, it is probably better to obtain this information sooner rather than later. Number 6. Step 5. Subpoena of witnesses. The method a party uses to obtain the attendance of a witness at court is by serving a subpoena on him. A subpoena is really just a notice in the form of a court order to a witness telling him that he is required to give evidence in court, under threat of penalty. The rules provide regulations relating to the service of these documents together with payment for transport and witness fees. Number 6.1. Subpoenas in the High Court. Number 6.1.1. A normal subpoena. Rule 38 of the High Court Rules deals with the subpoena of witnesses to give evidence at a High Court trial and should be read with Section 35 of the Superior Courts Act, which deals with the manner of securing attendance of witnesses. Whichever party wants to subpoena a witness to give evidence on his behalf simply draws up a subpoena which must correspond to Form 16 in the first schedule to the High Court Rules. The subpoena is then issued by the registrar and served on the witness by the deputy sheriff. Any party in a matter which is due to be tried before the court has a right and need not first obtain the leave of the High Court to have a subpoena issued and served on any witnesses the party believes may be in a position to give evidence on his behalf, or may possess documents or other physical pieces of evidence which a party thinks may be useful to his case. The right is somewhat limited in that the court may set aside a subpoena if it is certain that the witness who has been subpoenaed will be completely unable to assist the court in its determination of the issues raised at the trial. Previously, the court's power to set aside a subpoena if it is satisfied as a matter of certainty that the subpoena is unsustainable was derived from its inherent jurisdiction to regulate its own process and avoid abuse of its process, a power which, of course, it still enjoys. However, the power to set aside a subpoena is now contained in Section 36, Subsection 5 of the Superior Courts Act. A party may not use a subpoena to harass his enemies and drag them to court for no reason. A subpoena drafted in accordance with Form 16 informs the witness when and where he has to appear to give evidence and on whose behalf he will be required to give evidence. Number 6.1.2. Subpoena ducis tecum. In terms of Rule 38, subsection 1a, a witness may be required to bring with him to court any deed, instrument, writing, or thing that is stipulated in the subpoena. A subpoena that contains a direction to the witness that he must bring a stipulated deed, instrument, writing, or thing with him to court is known as a subpoena ducis tecum. The Latin words ducis tecum mean bring with you. Okay. A subpoena ducis tecum is an important procedural tool. It is the method by which a party is able to obtain access to documents or other items of physical evidence that may be important to his case, when these items are in the possession of persons who are not parties to the case. A subpoena ducis tecum, this supplements the discovery and examination procedures set out in Rules 35 and 36, which are used to obtain documents and other evidence in the possession of the other parties to the action. A witness who claims that the document in question is privileged must still comply with the subpoena, but must satisfy the registrar or the court that his claim of privilege is legally justified. Rule 38, subsection 1b of the High Court Rules provides that any witness who has been required to produce any deed, document, writing, or tape recording by means of subpoena ducis tecum is required to hand over that deed, document, writing, or tape recording to the registrar as soon as possible after he receives the subpoena. The reason for this is to allow the parties to inspect whatever it is and make copies or transcriptions if they wish, so that they are able to prepare for the trial. If the witness simply brought the items with him on the day of the trial, the parties would inevitably ask for an adjournment of the trial in order to allow them time to examine the items and assess the impact of this new evidence on the respective cases. By providing that the items must be handed to the registrar and may be examined by the parties before the date of trial, Rule 38, subsection 1b prevents unnecessary delays in the trial of the matter. Once the parties have had the opportunity of examining the items handed over to the registrar by the witness, the items, whatever they may be, will be returned to the witness. Number 6.1.3. Failure to comply with a subpoena. Form 16 of Schedule 1 to the High Court Rules, that is, the form for a High Court subpoena, includes a warning directed at the witness, setting out the penalty for failure to obey a subpoena. This is a fine of 300 Rand or 3 months imprisonment. Section 35 of the Superior Courts Act sets out in detail the consequences if a witness fails. First, either to come to court or to remain at court in compliance with the provisions of a valid subpoena, or secondly, fails to produce any document or thing in accordance with a valid subpoena ducis tecum, although this may be dealt with more properly under Section 36 of the Superior Courts Act, or lastly, deliberately evades service of the subpoena. Section 35, subsection 2 empowers the court to issue a warrant for the arrest of such a witness. Section 35, subsection 3 allows the court to order such witness to be detained with a view to securing his or her presence as a witness or production of any document or thing. In terms of Section 35, Subsection 4, the court may conduct a summary inquiry into the failure to obey a subpoena to attend any proceedings as a witness or to produce any document or thing by such a witness. If the witness does not have a reasonable excuse for his conduct, he may be sentenced to a fine or imprisonment for a period not exceeding 3 months. An attorney preparing a subpoena on behalf of a party should bear the following points in mind in order to ensure that the court will be able to deal effectively with the witness if that witness fails to obey the subpoena. Number 1. The subpoena must be properly served by the sheriff. Number 2. The subpoena should not be served too close to the trial date because the witness is entitled to reasonable notice that he has to appear as a witness. The circumstances of each case will determine what reasonable notice is. Number 3. All the witness fees due to the witness should either be paid to him or offered to him in the subpoena. And lastly, in respect of a subpoena ducis diacem, the document or thing must be sufficiently particularized. In practice, a paragraph is usually inserted in the subpoena offering the witness all the witness fees that may be due to him, as calculated in accordance with the tariff of fees framed under Section 42, Subsection 1 of the Supreme Court Act and under Section 37 of the Superior Courts Act when this section comes into force, which will be discussed below. It may not be enough, however, to simply offer the witness all the witness fees due to him. In certain cases, a witness is entitled to certain fees to cover the costs of traveling to court. A check for these fees must be included with the subpoena. If the fees are not included and the witness fails to arrive at court, the court will refuse to issue a warrant for arrest of the witness. The court will not issue a warrant if there is a possibility that the reason that the witness did not arrive is that he did not have sufficient funds to get to court. Recently, the principle that a witness should not be required to incur any disbursements has been extended to the payment or tender of the costs of producing, reproducing, photocopying, and collating the documents subpoenaed ducis diacem. It is worthwhile trying to secure the cooperation of witnesses. Before the trial, their presence may be required at an attorney's office in order to give a statement, or at counsel's chambers to be recognized, prepared for delivering testimony at trial. The attendance at these meetings cannot be enforced in terms of the rules. Also, a visit from a sheriff may be highly embarrassing, particularly if it is at the witness's place of work. For this reason, it is a useful practice to write to a witness in order to inform him that he is required as a witness before dispatching the subpoena. Sending a polite note should not be done, however, if it is likely that a witness will attempt to avoid service if forewarned of the sheriff's visit. Number 6.1.4. Calculating witness fees. Section 42 of the Supreme Court Act provides for the fees to which a particular witness is entitled. This particular act is unlikely to be relevant in this context much longer, however. The Supreme Court Act was repealed and replaced by the Superior Courts Act in 2013. Section 42 of the Supreme Court Act is to be replaced by Section 37 of the Superior Courts Act. However, Section 37 of this Act is not yet in force and will take effect on a date to be proclaimed. Until it is proclaimed, the old tariff under the Supreme Court Act remains applicable. Therefore, the discussion below proceeds on the basis of the Supreme Court Act, although its terms are essentially identical to its imminent replacement provision, Section 37 of the Superior Courts Act. Section 42 gives the Minister of Justice and Correctional Services, in consultation with the Minister of Finance, the power to prescribe a tariff of allowances to be paid to witnesses in civil proceedings. While a witness should not be left out of pocket for having given evidence, the guiding principle with regard to the financial compensation given to witnesses is that they should not be remunerated for evidence given in a court of law. It is easy to see that it would be unhealthy to pay witnesses for giving evidence, and a balance has to be achieved. Witnesses should not be financially prejudiced by giving evidence, but neither should they make a profit. The schedule provides for a subsistence allowance, traveling expenses and transport, and income forfeited, and applies to both the High Court and Magistrates Courts. The subsistence allowance provides for accommodation and meals. If it is necessary for the witness to hire a room for the night, the allowance provides for payment of the reasonable actual expenses. With regards to meals, a witness may either claim for the amount of 50 Rand a day or the reasonable actual expenses incurred for meals on submission of proof of the expenses to the satisfaction of the court manager, or registrar. No distinction is drawn between expert and ordinary witnesses. The subsistence allowance is not payable if the witness travel fare includes the cost of meals and accommodation. In the case of private transport, the witness may claim 92 cents per kilometer in the case of a motorcycle, or 1 Rand 30 cents per kilometer in the case of a motor vehicle, calculated along the shortest route. In addition, and provided satisfactory proof has been produced, a witness is entitled to be reimbursed for the reasonable expenses actually incurred in respect of parking and toll fees. In the case of public transport, an amount equal to the fare for the least expensive transport along the shortest route is permitted. Air transport may only be used if the court manager, registrar, or taxing master of a division of the High Court is satisfied that the use thereof is warranted and has approved that the witness may make use of air transport. As far as the income forfeited is concerned, and provided that satisfactory proof is produced, a witness who has forfeited income as a result of his attendance of a civil case is entitled to an allowance equal to the actual amount of income so forfeited, subject to a maximum of 1,500 Rand per day. In other words, if an important businessman is subpoenaed to court for 2 weeks, even though he may lose a few million Rand a day, he is only entitled to receive 1,500 Rand per day in compensation for his lost income. Special allowances are also provided for in unusual situations, however, where the court manager, registrar, or taxing master of a division deems it fair, he may approve the payment of an allowance not provided for in the schedule, or an allowance under circumstances not provided for in the schedule. Furthermore, deviation from the tariff may be permitted in the case of a witness residing outside the Republic of South Africa, or in any other case, provided the court manager, registrar, or taxing master of a division is satisfied that the application of the provisions of the schedule may cause financial hardship. The allowances prescribed in the schedule are also payable to a person who, of necessity, accompanies a witness on account of youth or infirmity owing to old age, or any other infirmity of the witness. However, where the expenses of a witness are provided for from any other source, no allowance that would otherwise be payable in terms of the schedule may be paid to the witness. Number 6.2. Subpoenas in the Magistrates Courts. In Magistrates Courts practice, subpoenas and subpoenas ducis decem are dealt with by Section 51 of the Act and Rule 26 of the Magistrates Courts rules. The form a subpoena takes in the Magistrates Courts is set out in Form 24 of the Magistrates Courts rules. A subpoena is issued in a manner very similar to that followed in the High Court, and is served in the same manner by the applicable sheriff. Rule 26, Subsection 4 provides that the subpoena must be accompanied by as many copies as there are witnesses to be summoned, together with the conduct money in each case. Subpoenas ducis decem are dealt with in terms of Rule 26, Subsection 3, and the subpoena needing to specify the document or thing required to be produced in evidence. In terms of Rule 26, Subsection 5, a magistrate may set the service of a subpoena aside if it appears that the witness was not given reasonable time to enable him to appear. Section 15 of the Magistrates Courts Act deals with witness fees in the Magistrates Courts. Number 7. Step 6. Special Evidence. Special rules apply to the following types of evidence, which have been categorized in this book as special evidence. Number 1. Evidence by an expert witness. Number 2. Evidence in the form of photographs, plans, models, and diagrams. Number 3. Evidence on commission. Number 4. Evidence by means of interrogatories. And number 5. Evidence on affidavit. Number 7.1. Expert evidence. While parties are obliged to make pre-trial discovery or allow examination of physical evidence, ordinarily there is no obligation on a party to reveal the nature and content of the oral testimony that the witness will deliver in court. An exception to this is expert evidence. Anyone may give opinion evidence if it is relevant in that it will assist the court appreciably, but the opinion evidence of an expert falls into a special category. Such evidence is necessary when a court lacks the specialist knowledge which is essential to enable it to decide certain issues in a matter. The evidence of expert witnesses is dealt with in terms of Rule 36, Subsection 9 of the High Court's Rules and Rule 24, Subsection 9 of the Magistrates Courts Rules. These two rules are identical. In terms of these rules, a party intending to call an expert must do two things. First, not less than 15 court days before the hearing, deliver a notice of his intention to call an expert. And secondly, not less than 10 court days before the hearing, deliver a summary of the expert's opinion, which must include his reasons for that opinion. In practice, these two steps are often combined into one, and the notice of intention to call the expert is combined with a summary of the expert's opinion. Any party failing to comply with these requirements will not be entitled to lead the evidence of the expert witness unless the court grants leave to do so, or all the parties to the matter give their consent. The rationale for this rule is to allow the opposing party to prepare himself to counter the expert's testimony, usually by calling an expert of his own. Without this rule, the opposing party would be taken by surprise at the trial and would be forced to request an adjournment in order to obtain his own expert evidence. The rule also allows the experts to exchange reports and views and possibly to eliminate unnecessary points of dispute between themselves. This process is usually facilitated by a meeting of the respective experts, resulting in the production of an expert minute, a written note of the conclusion of the meeting, which will be signed by both experts, although the practice in the various divisions will differ depending on what is contained in the division's practice directive. Although the required summary of the expert's evidence need be no more than a brief synopsis of the evidence, the summary should indicate the following. Firstly, the expert's qualifications and experience in order to establish him as an expert. And secondly, the facts and data on which the opinion is based. Number 3, the process of reasoning, if it is not a matter of ordinary logic used to arrive at the opinion. And lastly, the expert's reasoned conclusions, that is, the opinion. The main consideration when deciding what ought to be included in the summary is that the opposing party should not be taken by surprise. The summaries of expert opinions provided by attorneys in magistrates' courts matters frequently leave much to be desired. Often they provide only a vague conclusion in support of the relevant party's case, with no explanation as to how the opinion was arrived at. Apart from MVA claims, where a great deal of work tends to be conducted on a case before issue of summons, it is not uncommon, particularly in the magistrates' courts, for experts to be consulted for the first time just before the trial. This is hopelessly too late. Expert evidence often forms a key aspect of a party's case, and in such matters, a consultation with the expert should be arranged before the plaintiff issues summons or the defendant delivers his plea. Frequently, the expert opinion will determine whether or not a cause of action or adequate defense exists, leaving this aspect until the eve of trial is most undesirable. Number 7.2. Photographs, plans, models, and diagrams. Number 7.2.1. In the High Court. If a party decides that he wants to use a plan, diagram, model, or photograph as evidence during the trial of an action, notice must be given to the opposing party before the trial. The applicable rules are High Court Rule 36, Subsection 10, and Magistrates Courts Rule 24, Subsection 10. Although not identical, these rules are very similar. Rule 36, Subsection 10a of the High Court Rules reads as follows. No person shall, save with the leave of the court or the consent of all the parties, be entitled to tender in evidence any plan, diagram, model, or photograph unless he shall not less than 15 days before the hearing have delivered a notice stating his intention to do so, offering inspection thereof, and requiring the party receiving notice to admit the same within 10 days after receipt of the notice. The purchase of this notice is twofold. First, without giving notice to the opposing side, the plan, diagram, model, or photograph intended to be used in evidence may not be used. The second purpose is to obtain the consent of the opposing party to the admission of the evidence without proof. A party using such a notice to ask the opposing party to admit the plan, diagram, model, or photograph is, in effect, asking the opponent to admit the following. Number 1. The plan, diagram, model, or photograph is authentic. For example, a party may wish to tender in evidence at the trial a photograph of the Durban beachfront taken in 2009. By asking the opposing party to admit the photograph, the opposing party is being asked to admit that it is a photograph of the Durban beachfront taken in 2009, so that the party wishing to use the photograph does not need to call the person who took the photograph to give evidence of this fact. And secondly, the physical features shown on the plan, diagram, model, or photograph were present when it was drawn, made, or taken. To use the previous example, the opposing party is asked to admit that the photograph shows the physical features of the Durban beachfront in 2009 and was not tampered with in any way. In the case of Shield Insurance Co. Limited versus Hall, which concerned a plan drawn by a policeman of a motor vehicle accident scene, Galgett interpreted the implications of Rule 36, Subsection 10 as follows. I am of the view that if the prerequisites are established, Rule 36, Subsection 10 creates an admission only, number 1, as to the authenticity of the document, that is, it dispenses with the need to call the author of the plan or to provide other proof of its authorship, and number 2, as the physical features actually found by the author. It must be borne in mind that a plan or diagram without physical features should be a virtual nullity. A distinction was drawn in the above case between the physical features depicted in the plan and written statements reflected in the plan, which amount to an expression of opinion. For example, an indication on the plan as to where the collision took place is merely an expression of the author's opinion. The written statements were not taken to be admitted in terms of Rule 36, Subsection 10, and Galgett stated as follows. It follows from what has been said above that regard can only be had to the physical features depicted in the plan, viz., the road, the earth bank, the gap, the position of the vehicles and tracks as depicted by the policeman. Physical features would, in my view, include the measurements relating to these features. In terms of Rule 36, Subsection 10b, if the opposing party responds to the notice by delivering a written reply within 10 court days after receiving the notice, in which he refuses to admit the plan, diagram, model, or photograph, then the plan, model, diagram, or photograph will have to be proved at the trial. In other words, the persons who drew the plan or diagram or made the model or took the photograph will have to be called to give evidence that the plan, diagram, model, or photograph is accurate. If the person who drew the plan or diagram or made the model or took the photograph is no longer available, for example, the person who took a photograph of the Durban beachfront in 1970 might have died, some other person who is able to attest to the accuracy of the plan, diagram, model, or photograph will have to be called. For example, if the deceased person who took the photograph in 1970 was a newspaper photographer, the person in charge of the archives of the newspaper concerned could be called to attest that the photograph is the original photograph taken in 1970 and has not been tampered with in any way. Note that by refusing to admit the plan, diagram, model, or photograph and forcing the proof thereof, the opposing party takes the risk that the court will order him to pay the costs of this process in terms of Rule 36, Subsection 10b. This rule is particularly useful when building plans need to be used in evidence. In many cases, particularly if old buildings are involved, the building plans can only be found in the records of the municipal engineers or building inspectorate. Since the clerk in charge of the filing office where the plans are kept is only able to attest that, according to his records, these are the plans of the building in question filed at the offices of the municipal engineer, the admission of these plans without proof saves the time and expense of calling the clerk as a witness. Number 7.2.2. In the Magistrates Courts. The corresponding Rule 24, Subsection 10 of the Magistrates Courts rules is worded in a slightly different fashion. Rule 24, Subsection 10a and b corresponds to Rule 36, Subsection 10a. And Rule 24, Subsection 10 C and D corresponds to Rule 36, Subsection 10b of the High Court rules. These rules, although not identical, are very similar and have a similar effect. However, the time periods differ. In a magistrate's court's matter, the notice has to be served on the opposing party no less than 10 days before trial, and the opposing party has to deliver his objection within 5 days of receipt of the notice. Number 7.3. Evidence on commission. In certain cases, it may not be possible for some reason or other, for example, if the witness is bedridden or is located in a foreign country, to get a witness to court to testify at the trial of a matter. One way in which this problem may be overcome is for the court to appoint a commissioner, who will then go and take the evidence of that witness in the form of a deposition. The deposition may then be handed in as evidence at the trial of the matter. The court loses the advantage of observing the demeanor of that witness or putting questions to him in person, but this is still better than losing the evidence altogether. Number 7.3.1. In the High Court. A party who wishes to make use of this procedure will have to apply to court in terms of Rule 38, Subsection 3 of the High Court rules. Application is generally made after close of pleadings when the issues have been defined and it is clear what evidence will be required. A commission may be appointed at an earlier stage, however, when there is a danger that the evidence may be lost, for instance, due to the imminent death of a witness. The party making application has to show that it is convenient or necessary for the purposes of justice to order the taking of evidence before a commissioner. The issues the court will examine in order to determine this include the inability of a witness to attend court, the likelihood of evidence being otherwise lost, together with the relevance and materiality of the evidence. According to Erasmus, the following information must be set out in the affidavit in support of the application. A. The reasons why it is necessary for the purposes of justice that the ordinary way of taking evidence should be departed from. In this regard, the applicant should adduce sufficient evidence to support the inference that the commission is being sought on bona fide grounds to advance a legitimate case, and that he has acted with proper diligence in pursuing alternative remedies which might reasonably be available. B. The nature of the evidence to be given and its relevance. C. The names of the witnesses those evidence on commission is required, for the courts are reluctant to grant a roving commission to examine an unlimited number of people. The courts have, however, granted leave to take the evidence of named persons on commission, as well as evidence of any other person whose evidence becomes relevant or appears to be so as a result of the evidence given at the commission. Okay. The court has discretion as to whether or not to grant an application to hear evidence on commission. Erasmus states that the court is faced with the problem of vital evidence being lost if a commission de bene esse were refused, or if of allowing the production of evidence considerably weakened the defendant's inability to cross-examine foreign witnesses if the likelihood of a miscarriage of justice lies in the refusal of the application rather than the granting of it, the court will grant a commission. The procedure for the taking of evidence on commission is set out in Rules 38, Subsection 5, 6, 7, and 8 of the High Court Rules. The commissioner is appointed by the court and is generally a magistrate if the witness is present in the Republic, or a solicitor, attorney, or barrister if he is in a foreign country. Once the commissioner is appointed, he may subpoena the witness to appear before the commission if situated in South Africa. The witness is then examined on oath in the commissioner's presence and in the presence of the parties and their legal representatives. The witness adduces his evidence orally, and the parties are entitled to cross-examine and re-examine. A record is taken of the evidence given, and the transcript is presented to the registrar of the trial court. Number 7.3.2 in the Magistrates Courts. Section 53 of the Magistrates Courts Act deals with the commission's de bene esse in the Magistrates Courts. The wording of Section 53 differs from that of Rule 38 of the High Court Rules, but the effect and considerations involved are largely the same. Section 53, Subsection 1 provides only that notice should be given to the opposing side of a request for the appointment of a commissioner, unlike the express requirement in Rule 38, Subsection 3 of the High Court Rules for the request to be made by application. Jones and Buckle, however, hold that where the request is made prior to the trial, it should be made in writing as far as possible in accordance with the provisions of Rule 55 of the Magistrates Courts Rules, which provides for applications. The contents of the supporting affidavit should generally be the same as that indicated for the High Court practice above. Form 23 of Annexure 1 to the Magistrates Courts Rules is used to appoint the Commissioner. Rule 26, Subsection 2a and b provide for the issue of a subpoena in respect of a witness who is required to appear before a Commissioner within the Republic. The subpoena is sued out by the party desiring the attendance of the witness and issued by the Commissioner. Number 7.4. Evidence by means of interrogatories. Number 7.4.1. In the High Court. Examination by interrogatories may be thought of as a particular variant of the procedure for taking evidence on commission. Interrogatories are a set of questions which are drawn up by the parties and submitted to the court for approval, then sent to the commissioner who puts them to the witness. In this case, there is no representation or cross-examination by the parties. The procedure is not dealt with in the High Court Rules directly, but in Section 40 of the Superior Courts Act. A party to a High Court action is entitled to apply to court for leave to examine a witness who resides or is for the time being outside the area of jurisdiction of the court by means of interrogatories. The applicant will annex to his application the questions which he wishes to be put to the witness, and the respondent will usually ask for leave to put cross-interrogatories to the witness. If the application is granted, the questions, that is, the interrogatories and the cross-interrogatories, will be transmitted to a commissioner of the court, who will then put the questions to the witness and record the answer of the witness. The commissioner will send the answers to the registrar of the court, and they will be received as evidence at the trial of the matter. This procedure is obviously cheaper than that provided for in Rule 38, Subsection 5, in that it does not require the presence of the parties and their legal representatives. Its usefulness is limited, however, by the inflexible nature of the questions which are formulated in advance. The normal procedure for evidence is taken on commission de bene esse, however, allows the parties to respond to any unexpected information that emerges and is therefore more useful. Number 7.4.2 in the Magistrates Courts. Section 52 of the Magistrates Courts Act provides a limited procedure for interrogatories in the Magistrates Courts. Although its effect is similar to the practice in the High Court set out above, there are some differences. Apart from the need to show that permitting interrogatories in a particular situation is consistent with the ends of justice, interrogatories under Section 52 are only permitted in respect of witnesses who reside or are in a district other than that in which the case is being heard. This excludes witnesses who cannot attend court due to some other reason such as illness, in which case a commissioner will have to be appointed under Section 53, which deals with commissions de bene esse. The procedure set out in Section 52 neither provides for interrogatories to be used by a commissioner appointed outside of the Republic, however, nor indeed for the appointment of a commissioner at all. Section 52, Subsection 1 provides for the court on application of one of the parties to approve interrogatories and to frame some questions of its own. In place of a commissioner, these interrogatories are sent to the court within whose jurisdiction the witness resides or is. The court then subpoenas the witness and puts the questions to him together with such other questions as may seem to be necessary to obtain full and true answers to the interrogatories. It is possibly because this procedure does not apply to witnesses who are unavailable for reasons such as illness or located in a foreign country, that Section 53, Subsection 2 makes provision for a commissioner to put a witness such questions as have been transmitted to him on agreement between the parties. Okay, and then number 7.5, evidence on affidavit. Rule 38, Subsection 2 of the High Court Rules provides that in certain limited cases, the evidence of a witness in a High Court action may be given on affidavit. This procedure is suited to those situations in which strictly formal evidence is required from a witness, which will not be contested by the other side. If there is any reason to think that the other side will contest the evidence, the court will order that the evidence be given viva voce in court, so that it may be tested under cross-examination. In this regard, courts are more likely to grant leave to receive affidavit evidence where the evidence relates to matters that are formal in nature than where the evidence is contentious. An example of formal evidence that may be given by affidavit would be the testimony of a banking official providing the exchange rate on a particular date, where a party wishes to prove the precise value of a check in rand terms that has been made out in a foreign currency. Other factors which may be relevant in deciding whether or not to receive affidavit evidence are, for instance, lack of means, the expense of bringing the witness from a foreign country, and the illness of a witness. The production of proof by way of an affidavit in terms of Rule 38, Subsection 2 will be discussed in a pre-trial conference in terms of Rule 37, Subsection 5, discussed at number 7 below. There is no corresponding provision in the Magistrates Courts rules, but Section 22 of the Civil Proceedings Evidence Act will apply to both courts. It provides for an affidavit to be admissible on its mere production for proving facts where skill in a listed category of topics is necessary. These topics tend to be of a technical nature, including inter alia, biology, physics, and pathology. The deponent must be in a state or provincial service or attached to the South African Institute for Medical Research or a university. A copy of the affidavit must be served on the opposing party at least 7 days prior to its production. Number 8. Step 7. Pre-trial conference. Number 8.1. Pre-trial conference in the High Court. In terms of the High Court Rule 37, a pre-trial conference must be held between the parties no less than 6 weeks before the date of the trial. In general terms, the purpose of the Rule 37 conference is, as it is known in practice, is to curtail the proceedings as much as possible. To achieve this, the parties should try to define the points in issue between them, reach agreement on as many issues as they can, and decide upon the most effective way of conducting the trial. For example, which party has the duty to begin leading evidence, whether or not the parties will produce a combined trial bundle of documents to be used at the trial, and so on. The pre-trial conference also gives the parties a chance to curb costs and possibly to settle the matter. Rule 37A, which has now been repealed, was a separate rule that dealt with pre-trial conferences in the Western Cape Division. Number 8.1.1. Calling the conference. Rule 37 subsection 2A requires that once the plaintiff receives notice of the trial date, he must within 5 court days deliver a notice to the defendant specifying the date, time, and place for the pre-trial conference. If the plaintiff fails to deliver this notice and providing that 30 court days have passed since the date of the plaintiff's failure, then in terms of Rule 37 subsection 2b, the defendant may deliver a notice specifying the date, time, and place for the conference. The parties may agree to amend the date, time, and place for the conference, but it may not be held less than 6 weeks before the date of the trial. In practice, this time limit is often not adhered to, although several courts have issued practice directives in an attempt to ensure adherence to the rule. Rule 37 conferences have frequently been held only a day or two before the trial, which diminishes their potential value. This should be discouraged, and practitioners should endeavor to plan their matters to ensure that the conference is held as early as is practicable, albeit after discovery and after the parties have exchanged documents and further particulars. It has been held that although failure to comply with this time limit does not require an application for condonation, it may attract an adverse cost order if it results in a delay in the disposal of the case. Number 8.1.2. Setting the agenda. Not less than 10 court days before the date of the conference, the parties must each deliver to the other a notice in terms of Rule 37 subsection 4. This notice may be thought of as being each party's agenda for the conference. Rule 37 subsection 4 requires that the following be listed in the notice. Number 1. The admissions that are required from the opposing party. Number 2. The inquiries that will be directed at the opposing party which have not been included in the request for particulars for trial. And lastly, any other matters regarding preparation for trial and the party delivering the notice intends to raise for discussion. Number 8.1.3. The conference. In practice, Rule 37 conferences are often held between the advocates and the attorneys involved in the matter without their clients being present. Strictly speaking, the advocate's presence is not necessary either, but on the whole, attorneys appear to prefer to have the advocates present at the conference. The conference usually takes place in the chambers of the most senior advocate involved in the matter. Number 8.1.4. The Rule 37 minute. Immediately, that is, within a day or two after the Rule 37 conference has been held, a Rule 37 minute, a record of proceedings and the decisions reached is prepared, usually by the plaintiff's attorney from notes taken by the most junior advocate at the conference. It is, however, the duty of all the parties present to prepare and sign the minutes. The following points must be covered in the minute in terms of Rule 37, Subsection 6. Number 1. The place, date, and duration of the conference and the names of the persons present. Number 2. If a party feels that he is prejudiced because another party has not complied with the rules of court, the nature of such non-compliance and the prejudice must be recorded. Number 3. That every party claiming relief has requested his opponent to make a settlement proposal and that such opponent has reacted thereto. Number 4. Whether any issue has been referred by the parties for mediation, arbitration, or decision by a third party and on what basis it has been so referred. Number 5. Whether the case should be transferred to another court. Number 6. Which issues should be decided separately in terms of Rule 33, Subsection 4. Number 7. The admissions made by each party. Number 8. Any dispute regarding the duty to begin or the onus of proof. Number 9. Any agreement regarding the production of proof by way of an affidavit in terms of Rule 38, Subsection 2. And number 10. Which party will be responsible for the copying and other preparation of documents. And number 11. Which documents or copies of documents will, without further proof, serve as evidence of what they purport to be. Which extracts may be proved without proving the whole document or any other agreement regarding the proof of documents. This list provides a fairly good idea of what ought to be discussed at a Rule 37 conference. Furthermore, there is evidence that courts are becoming more strict about compliance with all the aspects of Rule 37, including the drafting of the minutes in the interest of a more efficient resolution of trials. Once the Rule 37 minute has been prepared, it is circulated to all the parties, and if they agree with the contents, it is signed. After it has been signed, the minute must be filed with the registrar in terms of Rule 37, Subsection 7, not less than 5 weeks before the trial date. Rule 37, Subsection 8 makes provisions for a judge to call upon the attorneys or advocates in an action to hold or continue with a conference before a judge in chambers. The judge may also require the presence of the parties. The judge may order the conference mero motu or at the request of one of the parties. Such a conference may be called at any time during the proceedings, but is most likely to be called for by one of the parties following a failed Rule 37 conference, at which progress was thwarted by stubbornness or equivocation on the part of one of the parties. Number 8.1.5. Special order as to costs. Rule 37, Subsection 9a gives Rule 37 its bite. The rule directs the court at the hearing of the matter to consider whether or not it is appropriate to make a special order as to costs against a party or his attorney because he or his attorney, firstly, did not attend a pre-trial conference, or secondly, failed to a material degree to promote the effective disposal of the litigation. The whole purpose of Rule 37 is to reduce the length and complexity of litigation by eliminating certain issues and getting the parties to agree on the manner in which certain pieces of evidence will be presented. Those attorneys who do not comply fully with Rule 37 and thereby prolong litigation may find themselves out of pocket if the court decides to invoke the provisions of Rule 37, Subsection 9a against them. Number 8.2. Pre-trial conference in the Magistrates Courts. Pre-trial conferences in the Magistrates Courts are dealt with by Section 54 of the Magistrates Courts Act, read with Magistrates Courts Rule 25. The purpose of the conference is very similar to its High Court counterpart. In terms of Section 54 of the Magistrates Courts Act, the following issues may be dealt with at such a conference. Number 1. The simplification of the issues. Number 2. The necessity or desirability of amendments to the pleadings. Number 3. the possibility of obtaining admissions of fact and of documents with a view to avoiding unnecessary proof. And number 4, the limitation of the number of expert witnesses. And lastly, such other matters as may aid in the disposal of the action in the most expeditious and least costly manner. An important innovation involving a new discretionary authority for magistrates used in the context of a Section 54 conference has been introduced in the 2010 rule amendments. In terms of Rule 1, Subsection 3, in order to promote access to the courts or when it is in the interest of justice to do so, a court may, at a Section 54 conference, dispense with any provision of the Magistrates Courts rules and give directions as to the procedure to be followed by the parties so as to dispose of an action in the most expeditious and least costly manner. While this innovation does not amount to the kind of inherent jurisdiction enjoyed by judges in the High Court, it certainly appears to be a shift in that direction. Unlike the Rule 37 conference provided for in the High Court's rules, it is not compulsory in terms of Rule 54, Subsection 1 of the Magistrates Courts Act to hold a pre-trial conference before the trial of a Magistrates Courts action. A pre-trial conference will only be held if the court decides sua motu, that is, of its own accord, to order it, or if one of the parties to the action makes a written request to this effect. The conference may be ordered or requested at any stage of proceedings, not merely in preparation for trial. Rule 22, which provides for the set down of a matter after close of pleadings, also provides a mechanism for a magistrate to become aware of the issues in a matter and to be given the opportunity to decide sua motu whether a Section 54 conference should be held. In terms of Rule 22, Subsection 4, on receipt of an application for a trial date, the registrar or clerk of courts must draw the court file and take it to the magistrate to consider whether a pre-trial conference in terms of Section 54 is necessary. The procedure for one of the parties to request a conference is to set out in Rules 25, Subsection 1 and 2. The request must be made in writing and should include an indication of the issues which the party making the request desires to be considered at the conference. The request is delivered to the registrar or clerk of court, who places it before a magistrate in chambers, who then decides whether or not the conference should be held. This procedure has seldom been used in practice. However, the provision for set down in terms of Rule 22, Subsection 4, means that the possibility of holding a Section 54 conference is considered by a magistrate in respect of every matter that goes to trial. This may well result in Section 54 conferences being held more often in future, which is a positive development. Note also the Civil Practice Directives for the Regional Courts in South Africa at paragraph 4.4, which gives further detail of the pre-trial conference procedure for matters in these courts. Number 9. Step 8. Final preparation for trial. Number 9.1. Advice on evidence. Once all the pre-trial proceedings have been completed, final preparations must be made for the trial. In High Court practice, it is quite usual for an advocate to be briefed by an attorney to draft what is known as an advice on evidence. An advice on evidence is an advice to the attorney on all the relevant aspects of the case to make sure that the client's case will be put as persuasively and comprehensively as possible at the upcoming trial, and to make sure that nothing in the preparation has been left out. Usually, the advocate discusses the following issues in the advice on evidence. Number 1. The form of the pleadings. Whether pleadings are properly closed, whether any pleadings are still required, whether any amendments to the pleadings are necessary, whether a request for further particulars for trial is necessary, etc. Number 2. The discovery process. Whether the process has been completed fully by both sides, etc. Number 3. The issues and the onus of proof. a list distinguishing those matters which are in issue from those which are not in issue, that is, those issues that are in dispute from those that are common cause, which of the parties bears the onus of proof in relation to each issue, which party has the duty to begin presenting evidence at the trial, etc. Number 4. The evidence available. What the documentary evidence is, what the oral evidence is, whether any further documentary or oral evidence is required, whether any expert witnesses are required, whether any models, plans, photographs, or diagrams are necessary, how the evidence should be adduced, etc. And lastly, number 5, general observations, whether any further preparation is required, the prospects of success at the trial, the quantum involved, which may assist the client in fixing a minimum settlement amount, etc. Unfortunately, the advice on evidence is also often undervalued by attorneys, and it is relatively common for attorneys to do little more than wrap their case file in a brief cover and dispatch it to counsel under cover of a one-line brief. When briefing counsel, attorneys should endeavor to set out their own views about the case, and at the very least, an attorney briefing counsel should analyze the pleadings, noting which averments have been admitted and which denied in order to establish what needs to be proven at trial, and make an assessment of what evidence will need to be presented at the trial. The other documents that should be included with the brief are copies of the pleadings, discovery documents, not just standard forms but thoughtfully completed, witness statements, medical or expert reports, and any document of an evidentiary nature such as contracts. The brief should list the documents with which counsel is briefed. Apart from setting out the analysis of the case by the attorney, the brief should raise any concerns or issues that the attorney wishes counsel to consider. Number 9.2. Case flow management. Significant developments have occurred under the direction of the Chief Justice acting in terms of the Superior Courts Act to better ensure access to justice and the speedy resolution of cases in the Superior Courts. In 2014, the Chief Justice published the norms and standards for the performance of judicial functions, in terms of which judicial officers' functions are to include judicial case flow management. The intention of judicial case flow management is to ensure that judicial officers take control of the management of cases at the earliest possible opportunity, play an active role in, and take primary responsibility for the progress of cases through the Superior Court. The introduction of a judicial case flow management signals a limited departure from the traditional adversarial system where judges adopted a hands-off approach to litigation to one in which they become involved from the outset, overseeing the preparation of the case for trial to ensure that cases are concluded without unnecessary delay. The same judicial officer is seized of a matter from inception and gives the final sign-off for the matter to proceed to trial. In some divisions, certain matters, such as RAF matters, may not be enrolled for hearing unless they are certified trial-ready by a judicial officer. In the Gauteng Local Division, Johannesburg, only trials involving expert evidence are subject to judicial case flow management. In each division, the case flow management directives, practices, or rules will provide which matters are subject to judicial case flow management, as well as when and how to ensure that each matter is successfully certified trial-ready. Practitioners are encouraged to have regard to each division's guidance in this regard. Number 9.3. Preparation of trial bundles. In High Court practice, one of the final tasks to be performed in preparation for the trial is the creation of bundles or collections of documents for use at trial. We have seen the documents relevant to the case are discovered by means of the Rule 35 discovery process. Each party needs to decide thereafter which documents it intends to use in evidence at the trial. This information should be disclosed to the opposing party in reply to a Rule 35 Subsection 8 notice. Ideally, the parties should attend the Rule 37 conference knowing which documents they intend to use at trial. One of the parties should then be given the task of gathering together the original documents, if possible, from both parties into one bundle in chronological order. Each page in this bundle of documents should be consecutively numbered, paginated. Then an index listing each individual document in the bundle, together with a page reference, should be prepared and affixed to the front of the bundle. The bundle should then be photocopied in order to produce enough copies for the attorneys and advocates involved in the matter, as well as one copy for the use of persons giving evidence at the trial. The judge is provided with the bundle containing the original documents. In this way, all the parties and the judge are provided with a common set of documents, uniformly indexed and numbered, to which the parties and judge may conveniently refer at trial. The task of collating, indexing, and paginating is usually that of the plaintiff as dominus litis, master of the suit. Practices vary slightly from division to division, and in some there are special requirements for the preparation of documents. There is no rule or convention pertaining to this practice in the Magistrates Courts, although the Civil Practice Directives for the Regional Court in South Africa at paragraph 4.2 sets out how bundles should be collated, numbered consecutively, and suitably bound. Number 9.4. Indexing and paginating the court file. The final task to be performed in High Court practice in preparation for trial is the indexing and pagination of the court file. This is required in terms of Rule 62, Subsection 4 of the High Court Rules, which provides that an applicant or plaintiff shall not later than 5 days prior to the hearing of the matter collate and number consecutively and suitably secure all pages of the documents delivered, and shall prepare and deliver a complete index thereof. This task is usually given to a responsible but junior member of the plaintiff's attorney's firm, invariably a candidate attorney. There will be a complete copy of all the pleadings in both the plaintiff's and the defendant's attorney's files, with the original documents filed at court. Usually, the candidate attorney will start by gathering together all the pleadings from the plaintiff's attorney's file. Next, he will place them in chronological order and number each page consecutively. He will then draft an index which lists each pleading in turn, with an indication of the page at which the pleading appears. The same procedure is followed for the notices and other processes, which are usually listed separately from the pleadings. He will then visit the General Office of the Registrar, armed with split pins, a spike or a corner punch, and the indexes. He will then request the court file and proceed to place all the pleadings and notices in chronological order and to paginate the papers by numbering each page consecutively. Finally, he will attach the index to the front of the bundle and secure the documents together with a split pin pushed through a hole created in the top left-hand corner of each document. Of course, other methods of securing the documents, such as plastic ring binders, may be used, and different divisions of the High Court may well have their own practices and rules for this procedure. There is no provision for sanction within Rule 62 itself, but in most divisions, failure to conform to the rule will result in the matter being struck off the roll with a suitable order as to costs, or at the very least in raising the ire of the judge hearing your matter. CIV3701 Stage 2, Part 2, Actions. C. Trial. An action culminates in a trial before a judicial officer who, after hearing the evidence brought by both parties and argument relating to the evidence and the law, delivers a judgment. At the trial, the allegations of the plaintiff's particulars of claim and the responses to these allegations by the defendant in his plea are supported by evidence, oral, documents, and real evidence, adduced on behalf of each party. The pleadings determine what evidence should be adduced, and no evidence may be given in relation to issues that have not been raised in the pleadings. The trial takes the form of a classic adversarial hearing, with most of the evidence being given orally. The parties determine which witnesses, documents, or examples of real evidence they wish to bring or place before the court, and they play the primary role in questioning the witnesses. The judicial officer, be he a judge or a magistrate, also referred to as the bench or the court, performs the largely passive function of umpire, ensuring that fair play prevails and that the parties follow the rules. The trial procedure is identical to a great extent in the High Court and the Magistrates Courts. Although the rules of court give the proceedings their structure, the nature of the evidence and the manner in which it is delivered are governed largely by the rules of evidence. In a criminal matter, the standard of proof required to convict an accused is proof beyond a reasonable doubt, whereas in a civil matter, the case needs merely be proven on a balance of probabilities. This means that if each party in a civil matter has given a different version of events, whichever version is more likely is the one that will succeed. In a criminal matter, however, even if the state's version is the more likely, the accused may be acquitted if there is a reasonable doubt. Number 1. Trial in the High Court. Number 1.1. Introduction. High Court Rule 39 sets out the procedures to be followed during the trial of an action in the High Court. Despite the procedures laid down, the Court has a discretion to vary any procedure in terms of Rule 39, Subsection 20. Furthermore, a High Court enjoys an inherent jurisdiction to vary its procedures in the interests of justice. Number 1.2. Parties not present. Failure on the part of one or other of the parties to appear at the trial may lead to default judgments being taken against them. Note that in terms of Rule 39, Subsection 2, a defendant who has been barred from pleading and who has failed to have the bar lifted may not, without special permission of the court, appear at the trial in order to defend the matter. Number 1.3. Open Court. In terms of Section 32 of the Superior Courts Act, all proceedings must be carried on in open court, which means that the press and public may be present, although this does not necessarily mean that the proceedings may be televised. This section reflects the important principle that justice should be seen to be done. In special cases, however, matters may be heard in camera, with the public and press excluded. What constitutes a special case will depend on the circumstances. Embarrassment and prejudice to a witness have been held to constitute a special case. The overriding criterion, however, is the proper administration of justice. Number 1.4. Recalcitrant Witnesses. Section 36 of the Superior Courts Act covers the way in which witnesses may be dealt with if they refuse to give evidence or produce documents. If a witness, number 1, refuses to take the oath or make an affirmation, or number 2, having taken an oath or having made an affirmation, refuses to answer such questions as are put to him or her, and number 3, refuses or fails to produce any document or thing which he is required to produce without any just excuse for his refusal or failure, the court may adjourn the matter for up to 8 days and commit the recalcitrant witness to prison for this period. The court may keep on adjourning the matter for up to 8 days, recommitting the recalcitrant witness to prison for the periods of the adjournment until he agrees to do what is required of him. Number 1.5. Duty to begin. At the start of the trial, the parties may request the court to hear argument and make an order as to which of the parties is under the obligation to adduce evidence first. In terms of Rule 39, Subsection 11 of the High Court Rules, either party may apply at the opening of the trial for a ruling by the court upon the onus of adducing evidence, and the court, after hearing argument, may give a ruling as to the party upon whom such onus lies, provided that such ruling may thereafter be altered to prevent injustice. Usually, the plaintiff is obliged to adduce evidence first, because the overall onus is on him to prove his case on a balance of probabilities. There is, however, a secondary evidentiary burden, which must be taken into account. This is a duty placed on a party to combat a prima facie case made by the opposing party. It is necessary to examine the admissions made in the pleadings to ascertain where the evidential burden lies. For example, a defendant in a defamation case may admit a defamatory remark was uttered, but claim that this remark was true in the public interest. A classic plea of confession and avoidance. In this situation, the plaintiff will no longer be obliged to prove defamation, but the defendant will be obliged to prove the statement to be true and in the public interest. In other words, the defendant now bears the evidentiary burden, or onus. It may be necessary to argue the issue of evidentiary burden if the parties have not already settled it at the Rule 37 conference. The question of the evidentiary burden is critical, and it is usually preferable for the opposing party to bear the evidentiary burden and therefore be given the right to begin. This is because it is easier to sit back and defend rather than to bear the burden of proving a particular issue or material fact. In order to be successful, the party bearing the burden of proof in respect of a particular material fact or issue must take positive steps and lead evidence to prove it. For the opposing party to be successful, however, it is sufficient merely for a party that bears the burden to fail to discharge it. There is no need for the opposing party to take positive steps by leading contradictory evidence to disprove the case of the party bearing the burden, unless the party bearing the burden has successfully proved the issue prima facie, thereby discharging the burden. In certain cases, there may be a number of issues involved in a matter, with the onus to adduce evidence in respect of certain of those issues being on the plaintiff and in respect of the rest of the issues the burden being on the defendant. In such cases, the plaintiff must adduce his evidence first, but only on those issues in respect of which the burden is on him. The defendant must thereafter, unless the court grants absolution from the instance, adduce evidence on those issues in respect of which the burden is on him. The plaintiff then has the right to call rebutting evidence on those issues in respect of which the burden was on the defendant. An action having commenced in one court will invariably proceed in that court until final judgment. Occasionally, however, the transfer of a part-heard matter to another court may be justified by considerations of justice and good sense. Number 1.6. Opening address. At the start of the trial, the party upon whom the burden of proof rests, or an advocate on his behalf, may briefly outline the facts he intends to prove. This brief outline of the facts is known as the opening address. Unlike the dramatic orations sometimes seen in television shows, which may in any event involve playing to a jury, the opening address is a sober summing up for the benefit of the judicial officer of the issues to be addressed. Counsel should take the court through the pleadings, explaining what the case is about and listing the averments that must be proven, distinguishing them from those which are common cause. Number 1.7. Plaintiff's case. After the opening address, the party with the duty to begin, usually the plaintiff, will lead the witnesses who are able to give evidence in support of his case. In terms of Rule 39, Subsection 8 of the High Court Rules, each witness shall, where a party is represented, be examined, cross-examined, or re-examined as the case may be by only one, though not necessarily the same advocate for such party. The parties present their cases in turn, beginning with the party that bears the evidentiary burden. Generally, the nature and scope of whatever evidence is led will have been determined by the pleadings. Evidence not covered by pleadings will usually be inadmissible and may only be relied on by a court where it is not prejudicial to the other party. Each witness called is led in his evidence in chief, where the witness sets out his version of events with the help of a fairly open questions such as what happened next from the advocate who called him. The reason for such open questions is that counsel who has called the witness may not ask leading questions, that is, questions that suggest an answer or assume facts that are in issue. Counsel for the opposing side then has the opportunity to cross-examine the witnesses in order to put the other party's version to him, probe inconsistencies, and to show any weaknesses in the evidence that the witness has presented. While it may be useful to discredit a witness completely by catching him out in a lie, this will seldom be possible. In any event, it is not necessary to show that a witness is dishonest in order to show that his evidence is unreliable or irrelevant or should otherwise be rejected by the court in favor of the other party's version. His evidence will be discredited sufficiently if it is possible to show from surrounding circumstances that the witness is mistaken, that his memory is inaccurate, or that he has reconstructed the events incorrectly. In order to achieve this, opposing counsel may ask leading questions in cross-examination. Counsel who originally called the witness then has the opportunity to re-examine the witness. This is used in order to patch up the damage done during cross-examination, if possible, by clearing up discrepancies which have arisen. However, no fresh matter may be raised at this stage. The re-examination of the witness should be devoted to topics pertinent to issues raised during cross-examination. This pattern is followed with all the witnesses, one after the other, until the party who began closes his case. After this, the opposing party opens his case, and the same pattern is followed in respect of each witness called. The opposing party thereafter closes his case. If the court wishes to call a witness, both parties must consent to that witness being called. At any time before judgment, however, the court may, on its own volition, or on the application of either party, recall a witness for further examination. The court may examine every witness, no matter who called that witness, and ask questions in order to clarify obscure points. It may ask leading questions, but if possible, should avoid doing so and should avoid descending into the arena. Number 8.1. Application for absolution from the instance. In the majority of cases, it is the plaintiff's advocate who accepts the duty to begin and leads the witnesses in support of his client's case. After all, the evidence for a plaintiff has been led. The plaintiff's case is closed. At this point, the defendant's advocate may decide to apply to the court without leading evidence for absolution from the instance on behalf of his client. He may do this without leading evidence because it is the plaintiff who bears the overall onus of proving his case on a balance of probabilities, and there is no obligation on the defendant to adduce evidence if the plaintiff has failed to discharge the overall onus by the end of his case. If the court grants absolution from the instance, the case comes to an end. The plaintiff may still pursue the matter, but in order to do so, he will have to institute a fresh action against the defendant. If the defendant decides to apply for absolution from the instance at the close of the plaintiff's case, the defendant or his advocate will address the court in support of the application. The plaintiff or his advocate will then address the court in opposition to the application. The defendant or his advocate may then respond to any matter arising out of the address on behalf of the plaintiff. The test the court will apply in deciding whether or not to grant absolution from the instance at this point in the proceedings is whether or not the plaintiff has succeeded in adducing sufficient evidence upon which a reasonable person might find in his favor. This is a much easier test to pass than that applied at the close of the case as a whole. For absolution to be granted at this early stage, the evidence that the plaintiff has adduced must be especially flimsy. For one thing, since the plaintiff's evidence has not yet been contradicted by that of the defendant, it will be accepted as being true unless it is inherently unacceptable or has been discredited by cross-examination. The court will refuse absolution if there are several reasonable inferences or possibilities arising out of the evidence, one of which favors the plaintiff's version of events. At the close of the case as a whole, however, the court will ask itself whether, on a balance of probabilities, it ought to, rather than might, find in favor of the plaintiff or defendant. Unlike the test applied after the close of the plaintiff's case, the court will weigh the various reasonable inferences or possibilities disclosed by the evidence in order to decide which of them is more likely. If neither the plaintiff nor the defendant has proved his case on a balance of probabilities, the court will grant absolution from the instance. Note that there can be no order for absolution from the instance where the burden of proving some of the issues was on the defendant, although the plaintiff has adduced evidence first because the burden of proving the other issues was on him. It will still be necessary for the defendant to lead evidence to rebut the onus on him. Number 1.9. Defendant's case. If the defendant's application for absolution from the instance at the end of the plaintiff's case is refused, or if he did not make such an application in the first place, he is obliged to open his case. If he is convinced that the plaintiff has not managed to adduce sufficient evidence to prove his claim on a balance of probabilities, the defendant may close his case immediately without leading any evidence at all. In order to do this, the defendant must be confident that the plaintiff's version of events, even if uncontested, is not strong enough to prove the claim against him on a balance of probabilities. To close the defendant's case without leading evidence clearly requires nerves of steel, as well as sound legal judgment on the part of an advocate or attorney acting for the defendant. In almost all such cases, the court will, minutes before, have turned down the defendant's application for absolution from the instance, which means that the plaintiff has adduced sufficient evidence upon which a reasonable person might find in his favor. Immediately thereafter, the court will be asked to reconsider the matter, without any additional evidence having been laid, in the hope that it will find in the defendant's favor. All that changes is the test that the court applies to the evidence before it. Once the defendant closes his case, the court has to consider whether the plaintiff has proved his case on a balance of probabilities. In other words, whether the plaintiff has adduced sufficient evidence upon which the court ought to find in his favor. In most cases, however, the plaintiff will have succeeded in constructing enough of a case to require an answer from the defendant. Evidence will therefore have to be laid on behalf of the defendant to counter the allegations made by the plaintiff, and the defendant will not be in a position to close his case without doing so. The procedure then is as follows. First, the defendant will address the court on what is intended to be proved in his defense, and thereafter he will lead witnesses in his defense. Each of these witnesses may be cross-examined by the plaintiff and re-examined by the defendant. Number 1.10. Closing Address. Rule 39, Subsection 10 of the High Court Rules deals with the closing addresses of the parties or their legal representatives. Upon the cases on both sides being closed, the plaintiff or one or more of the advocates on his behalf may address the court, and the defendant or one or more advocates on his behalf may do so, after which the plaintiff or one advocate only on his behalf may reply on any matter arising out of the address of the defendant or his advocate. In the closing address, counsel addresses the court on what has emerged from the evidence. It goes through the evidence to show what has been proven and discusses the performance of the various witnesses, their credibility, reliability, and the weight that he believes should be placed on the testimony of each witness. He may also make submissions with reference to the inherent probabilities in the case. Finally, he may be required to debate a point of law with his opponent and the court. Number 1.11. Reopening the case. Once a party's case has been closed, it may not be reopened without the permission of the court. Although the court may permit the reopening of a case at any time before judgment, the longer the trial progresses, the more reluctant the court will be to grant such permission. The party who wishes to reopen his case must show that, firstly, he used proper diligence to procure his evidence for the trial. This means that he must show that evidence has emerged which was not available or could not reasonably be obtained before he closed his case. Or if the evidence was available and obtainable, he must give an acceptable explanation as to why it was not adduced before he closed his case. Leave to reopen the case will not be granted if it appears to the court that the evidence was withheld intentionally. And secondly, the evidence which was proposed to be led is material and likely to be weighty. It need not, however, be so weighty that it would, if believed, be practically conclusive. Number 1.12. Inspections in loco. It is often easier to understand the oral evidence being given by a witness about certain events if one has visited and inspected the area in which the event occurred. This is obvious. Once someone has seen with his own eyes an area or structure or whatever, he is able to picture accurately in his mind what the witnesses are speaking about. For this reason, it often happens that the court, together with all the parties and their legal representatives, will take a trip to the place where the alleged cause of action in the particular matter arose, and will conduct what is called an inspection in loco. It may be necessary also to hold an inspection in loco for the purpose of viewing pieces of real evidence, such as defective concrete blocks that cannot be transported to court. When the judge is present, this is known as a judicial inspection. Inspections may also be carried out by parties without the judge present. At any time during the hearing of the trial, either party may apply to the court for inspection in loco to be held, and the court has a discretion to grant or refuse this application. Also, the court itself may decide that it wishes to conduct an inspection in loco. The best time to hold an inspection in loco is at an early stage of the trial. Notes are taken during the inspection in loco, and the nature of the observations made are read into the record upon return to court. For this reason, the legal representatives of the parties should ensure that features relevant to their respective parties' cases are pointed out to the judicial officer during the inspection in loco. Number 1.13. Reference to a referee. In terms of Section 38 of the Superior Courts Act, certain matters may be referred to a referee for inquiry and report. The following matters are specifically mentioned in Section 38. Number 1. Any matter which requires extensive examination of documents or scientific, technical, or local investigation which, in the opinion of the court, cannot be conveniently conducted by it. Or, secondly, any matter which relates wholly or in part to accounts. Or, lastly, any other matter arising. This means that if the court is confronted with a highly technical matter, it may call in the assistance of an expert in the relevant field. The referee then conducts an inquiry into the matter and produces a report. The court may adopt the report either wholly or in part, and either with or without modifications. It may also send the report back to the referee for further inquiry or consideration, or make any other order in relation to the report that it feels necessary or desirable. Once the court has adopted the report, it has the same effect as if it were the court's own finding in the matter. Number 2. Trial in the Magistrates Courts. There are few real differences between the trial procedure followed in the High Court and in the Magistrates Courts, and much of what is described above in relation to High Court practice applies equally to Magistrates Courts practice, except of course that a differently worded set of rules apply. The procedure relating to the way in which a trial in the Magistrates Courts is conducted is set out in Rule 29 of the Magistrates Courts Rules. Section 5 of the Magistrates Courts Act provides that, apart from exceptional circumstances, the trial must take place in open court. Rule 29, Subsection 1 of the Magistrates Courts Rules provides that the trial should take place at the courthouse from which the summons was issued, unless the court has ordered otherwise. Rule 29, Subsection 3 deals with the opening address by each of the parties. Before proceeding to hear evidence, the court may require the parties to state briefly the issues of fact or questions of law that are in dispute. This opening address serves substantially the same purpose as that in the High Court. There is possibly even more need for an opening address in the Magistrates Courts than in the High Court, since the former courts do not have the advantage of a compulsory Rule 37 procedure and the resultant minute. In the author's experience, however, practitioners appearing in the magistrates' courts frequently lead their first witness without any attempt to clarify the issues for the court. Rule 29, Subsection 4 is designed to make litigation more expeditious, that is, speedy, In terms of this rule, the court may decide to deal separately with one issue in the matter, which may determine the action and eliminate the need to deal with the other issues, which will become superfluous, that is, unnecessary. It corresponds closely to Rule 33, Subsection 4 of the High Court Rules. The rule provides that the court may miro muto order that a question of fact or law be decided either before any evidence is led or separately from any other question should this appear to be convenient. An example of a situation in which this might occur would be the decision of a court to decide on the merits of a claim or liability first, before deciding on the quantum, the amount of a claim. Rule 29, Subsection 5 provides that if the parties are agreed on the facts and the dispute between them is essentially a question of law, then the facts may be admitted and the court may give a judgment without hearing further evidence. In this situation, the parties have to agree on a set of facts to be admitted. If both facts and law are in dispute and the court believes that it can dispose of the matter by deciding the question of law only, then it is entitled to do so in terms of Rule 29, Subsection 6. An example of this would be a dispute relating to a defendant's liability in terms of a liquid document. There may be two areas of dispute. Firstly, one of fact relating to whether or not the defendant signed the document, and secondly, a question of law relating to whether or not the defendant's alleged liability under the document has prescribed. The question of law would arise if there was a dispute as to whether or not the document in question was an acknowledgement of debt or a promissory note, each of which prescribes after a different period. It may be argued that the proper course would have been for the defendant to raise an exception or special plea, but if this was not done, it remains true at this trial stage that the issue of prescription, if determined in the defendant's favor, will resolve the entire issue there and then. This is a good reason for the court to order that the issue of prescription be dealt with first. Rule 29, Subsection 7 and 29, Subsection 12 sets out the order in which evidence must be led. There is no substantial difference between the effects of these rules and the practice of the High Court set out above. The order in which evidence is given and the mode of questioning are the same. While the parties themselves may remain in the court throughout the proceedings, usually witnesses should sit outside court until called upon to testify. The plaintiff should give evidence before listening to that of his witnesses. This avoids the suspicion that the plaintiff has tailored his evidence to fit that of the witnesses and increases the probative value of his evidence. This applies equally to the defendant. Rule 29, Subsection 11 deals with the situation in which a party who has closed his case wishes to lead further evidence. The court will take into account the following factors in deciding whether or not to grant leave to a party to adduce further evidence. Number 1, the reason why it was not led timeously. Number 2, the degree of materiality of the evidence. Number 3, the balance of prejudice. Number 4, the general need for finality in judicial proceedings. And lastly, the stage that the particular litigation has reached. Rule 29, Subsection 12 deals with the recalling of a witness for further examination, and Rule 29, Subsection 14 deals with the closing addresses. These rules are broadly similar in effect to the practice in the High Court. Recalcitrant witnesses in the Magistrates Courts are dealt with in terms of Section 51 of the Magistrates Courts Act.